The Valley Current.
A man is standing in a federal courtroom, and deputy U.S. Marshals step up to him.
Yeah, right there in the open.
Exactly. They force him to take off his tie. They make him bend down and, pull the shoelaces out of his dress shoes.
Which is standard protocol, but still, wow.
Oh, it's visceral. Then they pull his hands behind his back, and the heavy metal handcuffs just click shut.
You could almost hear it in the room.
You really can. And some of his family and friends are sitting right there in the gallery, and they are openly weeping.
Just a completely devastating scene.
It is. He speaks, incredibly softly to his attorneys, gives the single brief nod, and is led out of a courtroom in Greenbelt, Maryland.
Headed off to begin a 6-year federal prison sentence.
Right. And, you hear a scene like that, and you might assume we're talking about, a cartel boss. Or some violent kingpin, right?
Somebody with a long, violent criminal history.
But we aren't.
Not even close, man. I mean, the man wearing those handcuffs who's stripped of his tie and laces is Thomas C. Goldstein.
And if you follow the legal world at all, that name, it hits like a thunderclap.
Oh, absolutely. It's a massive shockwave.
Thomas C. Goldstein is, or, was, an absolute titan of the appellate bar.
He was the guy you called when you needed a miracle.
We are talking about a private advocate who has argued 44 cases before the Supreme Court of the United States.
Wait, 44?
44. To put that in perspective for you, arguing even one case before the Supreme Court is the crowning achievement of most legal careers.
Yeah, most lawyers would retire happy after just one.
Exactly. 44 is astronomical. It puts him among the most prolific private advocates of his entire era.
It really does. He's in a completely different stratosphere.
Right. And he co-founded SCOTUS blog, which is this publication that completely and fundamentally reshaped how the public follows the Supreme Court.
Not just the public, but the media and the entire legal profession, too.
Yeah, he literally taught the practice of Supreme Court litigation to the brightest minds at Harvard and Stanford.
Teaching the best of the best.
And yet, on this specific Friday, July 24, 2026, this absolute champion of the legal establishment was sentenced.
For tax evasion, failing to pay taxes, aiding the preparation of false returns, and mortgage fraud.
It's just wild, the whiplash between that pristine elite resume and the visceral reality of federal handcuffs. It's incredibly hard to process.
It really is. It immediately forces you to look at the structural mechanics, like how a life actually gets from point A to point B.
Right. How does a career entirely predicated on upholding the rule of law at its highest possible echelon end with a marshal taking your shoelaces?
Yeah, that's the big question.
And that is the exact question we are tackling today. Today's deep dive examines the sentencing of Thomas C. Goldstein to 72 months in federal prison.
It's a fascinating subject.
To do this, we are drawing from an intensely, meticulously detailed technology and IP briefing published by Computer Law Group, LLP.
It's a really thorough brief.
Authored by the firm's managing partner, Jack Russo. What makes this source material so compelling is that it meticulously reconstructs the adjudicated record of this case.
It sticks to the facts, the court documents, the real timeline.
Exactly. Now, before we get into the weeds, I need to make something crystal clear to you, the listener.
This is a very important caveat.
Mr. Goldstein's convictions are currently on appeal in the Fourth Circuit. We are not here to play armchair psychologist today.
No, definitely not.
And we are certainly not here to moralize or pass personal judgment. Our mission in this deep dive is to impartially examine the documented facts.
Just looking at the legal arguments presented at trial and at sentencing?
Right. We want to trace what our source calls the dateable chain of choices that leads an elite professional to federal prison.
Yeah, that chain of choices is what really matters here.
We are going to look at the architecture of white-collar crime, the psychological trap of the cover-up, and the invisible, highly monetizable premium of professional trust.
And that framework is vital, honestly, because when you strip away the shock of who is involved, you are left with a very distinct set of mechanisms.
The mechanics of fraud and concealment follow recognizable patterns.
Right, regardless of whether the person committing them is a low-level clerk or a Supreme Court advocate.
Okay, let's unpack this. Let's start by walking right into that courtroom on sentencing day.
Because that hearing, wow. It stretched on for more than 6 grueling hours.
6 hours. And for those 6 hours, the judge, Lydia K. Grigsby, was essentially forced to weigh two entirely competing realities.
Two completely different versions of the same man.
Ultimately, she handed down a 72-month sentence. She ordered a staggering $3,103,427 in restitution.
That's over $3 million.
And perhaps most dramatically, she revoked his bond to order him into immediate custody. But how did she get to that number?
Well, you have to look at the prosecution's narrative first.
Right.
The government's team, which was led by Sean Beatty and Emerson Gordon Marvin, did not paint a picture of a man who simply lost control of his paperwork.
No, they didn't frame this as a filing error.
Not at all. They presented a narrative of massive calculated scale. They alleged that between 2016 and 2023, Goldstein consciously concealed more than $25 million in income.
I just want to pause on that number for a second. $25 million.
It's an astronomical sum.
Think about the logistics required to keep $25 million hidden over a 7-year period.
Right. That isn't a misplaced receipt in a shoebox.
Exactly. That is an active, ongoing administrative effort. You don't just forget about $25 million.
It requires a system. You have to actively manage that kind of concealment.
And by maintaining that system, the prosecution argued he deprived the federal government of over $9.5 million in unpaid taxes.
Yeah. But where the prosecution really dug in, where they hit hard, was the motive.
The why.
Right. They framed this conduct, and our source is careful to note it is quoting the prosecution here, not adopting the stance, as driven by pure, unrelenting greed.
And they backed up that claim by pointing to the lifestyle, right? They didn't just say greed and leave it hanging.
Oh no, they brought the receipts. Literally.
They talked in open court about Bentleys. They detailed globe-trotting international vacations.
They pointed at a watch worth $200,000.
A $200,000 watch. They even highlighted a moment where he allegedly paid off a romantic interest's tax lien.
Yeah, prosecutor Gordon Marvin stood up and explicitly argued that the court shouldn't view this as a mental health crisis.
Or like a tragic addiction.
Right. He framed it as a recurring daily choice to prioritize personal luxury over the law.
Especially considering Goldstein had repeated opportunities to come clean and right the ship over that entire decade.
Exactly. Which brings us to the alternate reality presented by the defense team.
Right. You have Jonathan Kravis and former Solicitor General Elizabeth Prelogar.
Absolute heavyweights in their own right. Elite lawyers defending an elite lawyer.
And their ask of the judge was 0 prison time. None.
Nothing but probation, basically.
They built their case around the concept of innocent mistakes, leaning heavily on the idea of a catastrophic error made by an accountant.
Passing the blame down the chain a bit.
But their core underlying narrative was that Goldstein was suffering in the grip of a deep-seated gambling addiction.
Right. The phrase they used was that he was playing with money he couldn't afford to lose.
Which, when you look at the sums of money moving around, suggests a level of compulsion that is just hard to fathom.
It really is. Kravis argued that this addiction, while perhaps not legally excusing the fraud, should be a massive mitigating factor for leniency.
The defense's position was that this wasn't a calculated mastermind robbing the system.
Yeah, they framed him as a man completely in over his head, spiraling out of control because of a psychological compulsion.
They also introduced a highly specific and frankly wild theory regarding the 2016 tax year.
This part blew my mind.
2016 is critical because it's the first charged year in the indictment.
Right, the starting line.
The defense stood up and claimed that Goldstein wasn't actually hiding 2016 winnings at all because he was technically a net poker loser that year.
A net loser?
Yeah.
How do you even argue that with millions involved?
Because they argued, a massive $9 million chunk of the money he was holding didn't actually belong to him.
Wait, what? Who did it belong to?
They claimed he was holding it for his poker backer, a Malaysian billionaire named Paul Fua.
Wow. I mean, it is a fascinating defense strategy. I'll give him that.
It is. But when you ask a jury to weigh the existence of a $200,000 watch and Bentleys against a narrative about holding $9 million for a Malaysian billionaire,
the jury simply didn't buy it. They just didn't.
They convicted him on 12 counts. And Judge Grigsby didn't buy the net loser theory either.
Not for a second. At sentencing, she explicitly addressed it.
She stated that the evidence showed he retained more than enough of those winnings to be classified as a net winner in 2016.
She looked at the entire timeline and saw a decade-long pattern of tax issues with multiple missed off-ramps.
So the judge lands on 6 years. But a sentence doesn't usually mean you go straight from the defense table to handcuffs.
No, especially not in white-collar cases under appeal.
Right. Usually the defendant gets to go home, pack a bag, get their affairs in order. But that didn't happen here.
No, it did not.
Let's talk about the tipping point, the bond revocation at the very end of this hearing.
This is the dramatic coda of the day. It's intense.
The defense naturally requested that Goldstein remain free pending his appeal to the Fourth Circuit.
Standard request.
Yeah.
But then the prosecution dropped a late-breaking bombshell on the court.
A huge bombshell. They allege that during the divorce proceedings with his estranged wife, Amy Howe,
Who, for context, is the co-founder of SCOTUS blog.
Right. They alleged Goldstein attempted to move an IRS credit worth roughly $3 million to her.
Wait, let me make sure I'm following this. He is actively under federal investigation, right?
Yes.
Standing trial for tax evasion and hiding assets, and the prosecution alleges he tries to silently slide a $3 million IRS credit to his estranged wife.
That's the allegation.
And he supposedly did this without notifying his federal probation officer.
Exactly. That was the government's claim. And this is all happening while, according to the prosecutors, his taxes remain unpaid for 2022 and 2023.
And totally unfiled for 2025.
It paints a picture of a man who is still actively moving massive pieces around the financial chessboard, even while the justice system is bearing down on him.
Right. Goldstein actually stood up in court a second time to push back on this, though.
He did. He told Judge Grigsby that the prosecution's claim was just a cryptic reference.
He said there were many more pieces to the puzzle regarding that $3 million maneuver. He looked at the judge and insisted he was not lying to the court.
But the judge had simply reached her limit. Throughout the pretrial process, Judge Grigsby had actually resisted several attempts by the government to have him detained.
She had given him a lot of leeway, the benefit of the doubt.
But this $3 million maneuver, combined with the unresolved ongoing tax issues, was the breaking point.
Yeah, she looked at him and said, "We've gone too far, Mr. Goldstein."
The fact that they were at the sentencing hearing and still couldn't get a clear bottom-line answer on this $3 million transfer proved her point.
So she denied the stay, revoked his bond, and the marshals moved in.
It's just, it's a stunning moment. You know, reading through the source text, an analogy popped into my head that I think perfectly captures the gravity of what is happening here.
Oh, I like analogies. What is it?
Imagine a small beach town, right? And they have this champion lifeguard. I'm talking about a guy with decades of saves, flags covering the walls of the station.
A local hero.
Exactly. He is the absolute most trusted person on the beach. But one summer, he starts swimming alone at night in waters way past his strength.
Getting in over his head.
And he starts losing bets he can't afford to admit. So what does he do? He quietly opens the lifeguard station's cash box and borrows from it.
Just telling himself he'll put it back after a good week, right?
Right. But the good weeks just fund more night swims. Eventually, to cover up the missing cash, he has to start fudging the station's official logbook.
The cover-up begins.
Then, the fudged logbook means he has to lie to the local bank when they ask about his debts.
It just snowballs.
Exactly. By the time the town auditors finally show up, the original missing cash is actually the smallest crime on the list. Because every single act of hiding required a new, more elaborate act of hiding.
What's fascinating here is the core takeaway of that analogy, because it maps perfectly onto the concept of professional trust.
It really does.
When the town finally catches that lifeguard, they aren't just angry about the missing cash.
Yeah.
I mean, the missing cash is almost secondary.
They are furious because he was the lifeguard.
Yes, the entire value proposition of his existence in that town was that he was the one person you didn't have to watch.
Exactly. I mean, think about it. When we look at the 72-month sentence, I have to ask you, how much of this punishment is just about the raw dollars and cents?
You mean the $9.5 million tax loss?
Right. How much is about the money, and how much of it is a penalty for the betrayal of his specific professional caliber?
It is inextricably linked to both, but the betrayal of trust is the massive amplifier here.
It has to be.
The source text makes a point to highlight Judge Grigsby's exact words from the bench. She explicitly cited his reputation.
What did she say?
She said, "It's very disappointing when we have this happening from somebody of a professional caliber of Mr. Goldstein."
Wow. That isn't just an offhand comment.
No, it's a recognition that trust is the central asset being violated. When an average citizen fudges a tax return, it's a crime.
Sure.
But when an elite Supreme Court advocate, someone who literally teaches the highest application of the law, commits fraud, it fractures the system's foundational trust.
Here's where it gets really interesting. If the defense team is leaning into this idea of innocent mistakes in addiction, how do you accidentally commit mortgage fraud?
That's a great question. You don't.
You don't just trip and fall into a fraudulent loan application.
No, it requires intent and action.
So to understand this, the briefing moves away from the sentencing day itself and meticulously maps out the chronology.
The timeline of how it all fell apart.
Right. It shows that a downfall like this is never a single dramatic leap off a cliff. It is a staircase.
That is a crucial distinction. The report is very disciplined about stripping away the moralizing and the dramatic rhetoric, and it just looks at the hard, documented dates.
The datable chain of choices.
Right. When you map it out on a timeline, you see a sequence of deliberate acts. And the terrifying part of the staircase mechanism is that each step is just small enough to rationalize in the moment.
It doesn't seem like a huge deal at first.
But structurally, each completed step makes the next, larger crime psychologically and practically easier to commit.
So let's actually walk you, the listener, down this staircase step by step, because it is wild.
It really escalates.
The first step down is in 2016, the first charged year. The jury convicted him on the allegation that his gambling winnings were understated by $3.9 million.
So year one, he's found to be a net winner and the money isn't reported accurately.
Then we step down to 2018, and this step involves one of the most vivid cinematic details in the entire adjudicated record.
Oh, the duffel bag.
According to the indictment, Goldstein returned from a trip to Macau carrying a duffel bag.
And inside that duffel bag was approximately $968,000 in physical cash.
Stop. Just think about the physical reality of that. Almost $1 million in cash.
It's insane.
I mean, how heavy is that? How do you move through an airport with it? It's not a rounding error on a spreadsheet. It is a physical mass of money.
You definitely feel the weight of it on your shoulder.
And what's wild is that he actually declared it at customs. He walked up to the border agent, declared the duffel bag as gambling winnings, and followed the rule at the border.
He did the right thing right there.
But somehow, that massive physical sum of cash never migrated onto his tax return.
Exactly. He navigated the immediate hurdle at customs, but the compliance just stopped there.
Right. Then the staircase continues down into 2020 and 2021. The indictment details how he engaged in the digital world.
The crypto phase.
It alleges he explicitly checked no to questions about cryptocurrency activity on his tax returns. He checked no despite having over $10 million in cryptocurrency transactions during that period.
10 million, that's a lot of activity to just ignore on a form.
Which brings us to the absolute bottom of this staircase in 2021. This is the step that resulted in the longest concurrent sentence of the entire case.
The full 6 years.
The mortgage lies. Goldstein goes to get a $1.98 million loan on a home in Washington.
A nearly $2 million mortgage.
But to get a loan of that size, you have to answer very specific liability questions on the application. The government alleged, and the jury convicted him of, falsely answering those questions by completely omitting more than $14 million in outstanding poker debts.
Think about the ratio there. He is hiding $14 million in debt just to secure a $2 million loan.
It's mind-boggling. To try and understand the internal mechanics of a person making these choices, because again, this is a brilliant legal mind, the briefing applies a very famous framework.
Donald Cressy's 1953 fraud triangle.
Right. Can you explain that for us?
Cressy's framework is basically the bedrock of modern auditing and fraud examination. It argues that for any occupational fraud or trust violation to occur, 3 specific elements must be present simultaneously.
Pressure, opportunity, and rationalization.
Exactly. If you are missing one, the fraud usually doesn't happen. The source text takes Cressy's triangle and overlays it perfectly onto the documented timeline of the Goldstein case.
Let's break those 3 legs down so you can really see how this works. Leg 1, pressure. And the triangle doesn't just mean like, I want more money.
No, it's more specific than that.
It specifically demands a non-shareable financial pressure. What does that mean?
A non-shareable pressure is a debt or a financial crisis that the person feels they absolutely cannot confess to anyone else. It's a secret that threatens their status.
Oh, wow. So they feel totally isolated by it.
Right. During the trial itself, Goldstein took the stand and testified that he lied to the mortgage lenders for a very specific reason.
To keep his massive debts a secret from his wife?
That is the textbook definition of a non-shareable debt. The internal pressure to maintain the facade at home drives the external fraud at the bank.
Okay, so that's the pressure. Leg 2 is opportunity.
Opportunity is about the structural ability to commit the act and get away with it. Here, the opportunity was uniquely profound.
How so?
Well, Goldstein wasn't a mid-level manager. He was the sole owner of his highly prestigious Supreme Court boutique firm from 2016 until it wound down in 2023.
So nobody was looking over his shoulder.
Exactly. He had total unquestioned control over the firm's books. But beyond just internal control, he possessed the opportunity that comes with elite status.
A prestige factor.
Right. As a renowned Supreme Court advocate, he benefited from the natural, almost reflexive deference that mortgage lenders and even the IRS extend to someone of his stature.
A loan application from Thomas E. Goldstein simply does not trigger the same skeptical scrutiny as an application from an average person.
It just doesn't. Which brings us to the third leg, the one that I think is the most fascinating. Rationalization.
This is the crazy part. How does a person who literally teaches the law to Harvard students swear committing mortgage fraud with their own self-image?
You have to find a way to tell yourself you aren't a criminal.
Yeah.
And we actually heard this rationalization in his own words from the witness stand.
What did he say?
He described his conduct as self-destructive.
Which implies a personal failing, sure.
But he vehemently insisted it wasn't criminal. He characterized the omissions as innocent mistakes.
Innocent mistakes.
Because this is how rationalization functions. It acts as a psychological shock absorber. It preserves the actor's self-image as a fundamentally good, smart person who is just navigating a temporarily impossible situation.
The briefing actually takes this concept a step further and introduces something behavioral scientists call the escalation loop.
This is where it gets really dangerous.
Researchers in this field, like Welsh, Ordonez, and Eugene Soltis, have demonstrated that small, early ethical transgressions actually rewire how you approach the next decision.
It changes your brain.
If you understate unpacks here, it enables what psychologist Albert Bandura called moral disengagement. Basically, committing the small bad act makes it neurologically and psychologically easier to commit a slightly bigger bad act the next time.
It creates a self-sustaining feedback loop. You commit a small transgression, you normalize it through that rationalization we just talked about.
Right.
And then inevitably you have to commit a larger transgression just to cover up the first one.
It's like quicksand.
Yeah. When you complete that cycle, it actually increases your overall concealment pressure, which feeds directly back into the pressure leg of the fraud triangle.
It demands an even larger transgression the next time around. Eventually, the cover-up itself becomes the primary driver of a criminal behavior.
But before we take all of this behavioral psychology as absolute gospel, our source material includes a really crucial caveat.
I'm glad you brought this up. It demands that we maintain some strict epistemic discipline.
This is a vital point for anyone trying to analyze white-collar crime. The briefing explicitly warns us against relying too heavily on behavioral science literature to explain human motives.
Why is that?
Because that specific field has recently been rocked by massive integrity scandals.
Right. Famous studies on honesty and unethical behavior by high-profile researchers like Dana Riley and Francesca Gino have faced severe retractions recently.
It's a huge mess in academia right now.
Why? Because independent investigators found fabricated data in their studies.
The sheer irony is staggering.
It really is. Researchers who built their entire careers studying why people lie were caught producing dishonest data.
It is deeply ironic, and it serves as a massive caution sign. Because of those scandals, the briefing insists that we must anchor our analysis entirely on the adjudicated timeline.
We have to look at the hard dates on that staircase of escalation.
Right. We cannot try to read Goldstein's mind or rely on psychological generalizations that might be rooted in flawed science.
But the dates of the tax filings, the date of the customs declaration for the duffel bag, the dates on the mortgage applications, those are empirical, documented facts.
If we connect this to the bigger picture, to prove that this staircase mechanism and the trap of the cover-up aren't just unique to Thomas Goldstein, the briefing zooms out.
It looks at how the federal justice system treats other fallen titans.
It brings in 4 incredible comparators.
Yes, the source places the Goldstein case alongside some of the most recognizable white-collar defendants in modern American history.
Bernard Madoff, Elizabeth Holmes, Sam Bankman-Fried, and Martha Stewart.
Let's just look at the raw numbers of their sentences for a moment. Bernie Madoff received 150 years.
Basically a life sentence.
Sam Bankman-Fried received 300 months, which is 25 years. Elizabeth Holmes got 135 months, or just over 11 years.
Significant time.
Goldstein is currently at 72 months, pending his appeal. And Martha Stewart, she served 10 months in total, 5 in federal custody, 5 in home confinement.
The report asks us to map these 5 cases on a conceptual graph with 2 axes.
The scale of the financial loss on one axis and the severity of the sentence on the other.
And when you plot them out, a jarring contrast emerges immediately. Look at Martha Stewart. The actual financial loss she avoided by trading her ImClone stock was only about $45,673.
That's practically nothing compared to the others. Goldstein's restitution order is over $3.1 million. Madoff's numbers were in the billions.
And yet, Stewart still went to federal prison. Why?
Think about your own workplace, or even just conflicts in your own life. Why does the justice system, and frankly, human nature, consistently punish the subsequent concealment, the panicked cover-up, so much harder than the original hidden act?
Because of what the briefing terms the cover-up premium.
The cover-up premium, I like that phrase.
When you analyze all 5 of these cases, the common denominator is that the very first step of deception was incredibly small compared to the eventual catastrophic fall.
Let's walk through them.
Madoff's multi-billion-dollar Ponzi scheme didn't start as a master plan to steal billions. It began simply as a desperate effort to cover up some early, embarrassing trading losses.
And Elizabeth Holmes.
Her massive fraud at Theranos started as overly optimistic capability claims about a blood testing technology she truly believed she could eventually invent.
Fake it till you make it, basically.
Exactly. Sam Bankman-Fried's collapse began with internal transfers between accounts that he mistakenly believed he could easily reverse and make whole.
And Martha Stewart's ordeal began with a simple relayed tip over a phone call.
And Thomas Goldstein's began, according to the jury verdict, with one understated tax year back in 2016.
The first step on the staircase is always the smallest.
But the hammer of the justice system always comes down on the cover-up. Let's look closer at Martha Stewart. She did not go to federal prison for the initial insider trading tip.
Wait, really?
Yeah, in fact, the actual securities fraud count against her was dismissed mid-trial.
Oh, wow. I didn't know that.
She went to prison for the false cover story she meticulously provided to federal investigators after the fact.
So the act of concealment became the conviction, and we see that exact same dynamic play out with Goldstein. Think about it. His longest concurrent sentences, the 6 years, were not handed down for the tax evasion itself.
No, they were for the lies he told to the mortgage lenders to hide the staggering $14 million in debt.
Furthermore, his bond wasn't revoked because of the original tax charges. It was revoked over the alleged $3 million credit maneuver that happened during the investigation and bond period.
The justice system punishes the cover-up so severely because a cover-up demonstrates an ongoing, willful, and calculated defiance of the law.
It proves it wasn't just a momentary lapse in judgment. It was a sustained campaign of deception. So what does this all mean? If this cycle of pressure, opportunity, and rationalization is so well documented, and the defense team vehemently argued that Goldstein was completely in the grip of a deep-seated gambling addiction,
Right.
Why didn't the judge show leniency? Why didn't the addiction argument work to reduce his time?
To understand why the addiction mitigation failed so completely, we have to wade into the actual mechanics of federal sentencing law, specifically the U.S. sentencing guidelines.
The rule book.
Right. The defense's theory didn't just fail to persuade the judge. It hit a massive, deliberate brick wall that is hard-coded into those guidelines.
I need you to explain this to me because it seems counterintuitive. If someone is truly sick, doesn't the law usually account for that? What is the history here?
It used to be more flexible, but back in 2003, Congress and the Sentencing Commission passed Amendment 651.
Okay, what did that do?
This amendment explicitly added a line to Section 5H1.4 of the guidelines that reads, quote, "Addiction to gambling is not a reason for a downward departure."
They literally wrote gambling addiction out of the rule book.
They essentially closed the front door on using it to get a lighter sentence, signaling that they viewed gambling as a behavioral choice rather than an exculpatory disease in the context of financial crimes.
But lawyers, especially elite appellate lawyers like Goldstein's team, are paid to find the side doors when the front door is locked.
Exactly.
What were the surviving doctrinal doors for mitigation that they could try to force open?
There are essentially 2 main pathways left. The first is Section 5K2.13.
Okay.
This section allows for a departure if the defendant suffered from a significantly reduced mental capacity that contributed substantially to the commission of the offense.
So a defense team can argue that a severe addiction impaired their client's volition so deeply that it reaches the level of diminished capacity.
Right. The second door opened after a landmark Supreme Court case in 2005 called United States v. Booker.
Okay, hold on. A Booker variance. You hear this term thrown around in legal thrillers all the time. What does that actually mean for a judge sitting in a courtroom? Explain it like I'm 5.
Before 2005, federal judges were essentially acting like human calculators. The sentencing guidelines were mandatory.
So they had no choice.
Right. You plug in the crime, you plug in the criminal history, and the grid spits out a narrow range of months. The judge had a sentence within that range.
But in the Booker decision,
the Supreme Court ruled that making these guidelines mandatory violated the Sixth Amendment. So they made the guidelines advisory.
oh, wow, so they had more freedom.
This gave judges back their human discretion. A judge can now grant a Booker variance, which means they look at the general sentencing factors, things like the history and characteristics of the defendant, and decide to give a lighter sentence outside the grid.
This is why defense attorneys spend so much time gathering character letters and appealing to a judge's empathy.
Because since 2005, the judge actually have the power to listen.
So the side doors definitely exist. Why did they slam shut for Goldstein? The briefing walks through a really fascinating split in the case law that perfectly maps onto this exact situation.
It is a brilliant piece of legal analysis. Let's look at the precedents. On one side of the split, you have cases like United States v. Sadolski and United States v. Chikura.
What happened in those?
In these cases, the federal courts actually allowed mitigation based on compulsive gambling. They granted lighter sentences because they found that the gambling drove the fraud, and this is the absolute critical part. The proceeds of the fraud went strictly and directly back into the casino.
Okay, I see. So as long as the stolen money stays on the casino table, the court might view it as a pure compulsion.
Right. The stolen money purely fed the addiction.
But what is the contrast?
The contrast is found in a case called United States v. Quinn. Interestingly, Quinn was also an attorney, and he was also involved in an employment tax case.
A very close parallel.
Very close. In Quinn, the court completely denied the request for a lighter sentence based on addiction.
Why?
Because the court followed the money. The concealed funds didn't just go to the casino, they went to fund a lavish personal lifestyle.
Oh, wow.
Because the money was spent on personal enrichment and luxury goods, the court ruled that the addiction did not contribute substantially to the crime in a way that warranted mitigation.
The causal link between the illness and the crime was broken by the lifestyle spending.
Exactly.
When you connect that Quinn precedent back to Thomas Goldstein, the prosecution's entire framing at the sentencing hearing suddenly makes perfect surgical legal sense.
It was incredibly strategic.
When the government stood up and spent time talking about Bentleys, globe-trotting vacations, and a $200,000 watch, they weren't just being theatrical.
They weren't just trying to make him look greedy to the gallery.
Right. They were specifically, tactically invoking the Quinn precedent.
Exactly. It was a calculated legal maneuver designed to legally block that mitigation door. The law draws a very strict, and some might argue harsh, line.
Yeah, it's very black and white.
A federal judge might find the room to forgive, or at least mitigate the punishment for, a defendant whose stolen money goes straight to the blackjack table.
But the law will absolutely not forgive a defendant whose concealed money goes toward buying a Bentley.
The presence of a lavish lifestyle defeats the diminished capacity argument every single time. This raises an important question. It brings us to the ultimate currency that Goldstein was trading on throughout this entire decade-long staircase.
Right. We've talked about duffel bags of Macau cash. We've talked about millions in cryptocurrency. But his most valuable asset wasn't any of those tangible things.
His most valuable asset was his reputation.
And that is the central theorem of this entire briefing. In the world of high finance and elite law, trust isn't just a warm, fuzzy feeling or a good reputation at the country club.
Trust is a highly monetizable asset. It functions as an operational credit line.
Let's explore the mechanics of that, because the briefing outlines how this credit line of trust was effectively spent across 3 distinct layers. Layer 1, his own staff and accountants.
Right. Think about the internal dynamics of a law firm. Goldstein was the sole owner of a prestigious boutique firm.
He was the boss.
His internal team, the accountants and clerks, inherently trusted his characterization of the firm's books.
Of course they did.
If the boss, who happens to be a legendary Supreme Court advocate, tells you a specific massive payment is a legal fee rather than a personal poker debt, the staff is highly likely to defer to his authority.
The trust basically suppresses any internal audits.
Exactly.
Layer 2, the IRS. How does the IRS give anyone a pass?
Well, the IRS, as a sprawling bureaucracy, has to allocate its auditing resources.
They can't check everyone.
Right. It naturally extends a practical level of deference to sophisticated, elite professionals. A complex tax return, filed by a famous Harvard-affiliated lawyer, simply doesn't set off the same immediate blaring alarms as a messy return filed by a business owner with a history of shady practices.
The sheer prestige of his professional standing acted as a bureaucratic shield.
And layer 3, the mortgage lenders.
Right.
And this is the layer that resulted in the massive 6-year sentence. When Goldstein walked in to get a $1.98 million loan, the lenders took his disclosures at face value.
They trusted the signature of a renowned appellate lawyer.
Because of that trust, they extended nearly $2 million in capital against paperwork that, according to the jury's final verdict, actively omitted over $14 million in staggering poker debts.
The trust was the collateral for the fraud.
The briefing introduces imagery from a business ethics scholar named Todd Haw to explain how this dynamic finally plays out in the courtroom.
What does he say?
Hull says that when an elite professional decides to take the stand in their own defense, it is the equivalent of pushing all your chips to the center and trusting that the judge and jury will see you the same way you see yourself.
Pushing all your chips in, wow.
And that is the ultimate gamble for someone used to winning on their reputation.
Yeah.
Goldstein took the stand for a day and a half.
He pushed all his chips in.
He utilized all of his formidable appellate communication skills, hoping his reputation and his framing of these acts as innocent mistakes would win the jury over.
But it didn't. The jury convicted him on 12 counts. They listened to him, they looked at the evidence, and they definitively did not see him the way he saw himself. This highlights what the source perfectly calls the double-edged sword of trust.
Yes, and this is the tragedy of white-collar crime. Trust is a unique asset because it can be spent twice in a fraud case.
Spent twice.
It is spent the first time as collateral to execute the fraud, getting the staff to look the other way, getting the IRS to accept the return, getting the bank to issue the loan.
Right.
But it's spent a second time and entirely depleted at sentencing. The violation of that high level of trust becomes the very justification for a harsher punishment.
We saw that exact dynamic on full display with Judge Grigsby. It was incredibly poignant.
It was.
In the exact same breath that she used to condemn the vast breadth and seriousness of his tax and fraud violations, she explicitly praised his groundbreaking work with SCOTUS blog and how it reshaped the legal community for the better.
It proves that the higher the pedestal of trust you stand on, the harder and faster the fall when that trust is broken.
It brings us perfectly back to your lifeguard analogy.
Yeah, when the dust settles, the town is devastated, not just because the cash box is empty, but because the one person they firmly believed was beyond reproach was the one quietly emptying it while everyone else slept.
So as we wrap up this deep dive, let's summarize the core lessons we've uncovered from this meticulously documented source material.
That's a lot to take in.
It is. The fall of an elite advocate like Thomas C. Goldstein is not a story about a sudden, inexplicable loss of a moral compass overnight.
No, it's about a structural, heavily documented staircase of rationalized choices.
It is about the failure to take the numerous exit ramps to come clean when they were available over a decade. And most profoundly, it is a stark lesson in the devastating cost of spending professional trust as collateral to hide a spiraling secret.
The structural mechanics of white-collar crime remain remarkably consistent, whether you are hiding billions of dollars in a Ponzi scheme or a few million in a duffel bag.
The cover-up always, inevitably, demands a higher price than the original sin. I want to leave you, the listener, with a final provocative thought derived directly from the discussion questions posed in the briefing. I want you to look closely at your own organization or your own business.
Think about the people you work with.
Look at your compliance program. Does it actively monitor all three legs of Cressy's fraud triangle: pressure, opportunity, and rationalization?
Or does it politely assume away the risk for the most senior, the most trusted, the most indispensable people in the room?
Does your organization operate on the assumption that the lifeguards of your business don't need watching? Because as this deeply tragic case proves, the deeper the trust, the wider the blind spot.
It's a sobering thought.
Led by Jack Russo, Computer Law Group LLP is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at computerlaw.com and his team at www.computerlaw.com, where the newsletter we refer to is published in detail and readily available, commitment-free with no paywalls or other charges.
Tune in next time on The Valley Current.